Good evening, everybody. To Attorney Carol Hallstrom, to Attorney Frank Goldsmith, to Chief William Anderson, to County Sheriff Van Duncan, to Ms. Oralene Simmons, to all distinguished guests assembled, and the community of Asheville, North Carolina, and Buncombe County. There's a powerful poem that results. There's a destiny that makes us brothers and sisters. None goes this way alone. All we send into the lives of others come back into our very own. And then there's a Negro spiritual that says, if I can help somebody as I travel along this way, my living will not be in vain. With these sentiments in mind, on behalf of the United Community for Justice, various organizations and groups assembled of Asheville, North Carolina, we and the congregation of St. James African Methodist Episcopal Church extend to you pleasant greetings. Welcome to our very first community forum, whereby we have come to begin a series of community discussions concerning the national issues of Trayvon Martin and how we should respond to the aftermath as a community and establish how to handle interactions with law enforcement. Tonight's forum will only serve as the beginning of such a dialogue, and from this further deliberations can be established. And by way of announcements, we want to invite everybody, if you haven't tried it already, we have some hot St. James croaker fish next door. So please visit our kitchen, and just a little bit grease won't hurt you. But nevertheless, we want to say welcome, welcome, welcome. And just give yourselves a round of applause for being here as concerned citizens of our country and nation. And let me take this time to present a very hardworking woman, Attorney Carol Hallstrom, chairperson of the United Community for Justice. Let's give her a hand as she comes.
Good evening. Look what we pulled off in such a short time. I, too, congratulate you for being here tonight. I'm Carol Rogoff Hallstrom, and I'm one of the organizers of tonight's convening. And certainly on behalf of the organizers and Pastor Edwards, I think on behalf of everybody here, we want to thank you for not only hosting us, but for making us all feel so very welcome. So please, for the pastor, for St. James AME, thank you. Thank you so much. Look around, and I'm reminded that quite deliberately, we are an interracial and an interfaith gathering. That we are an interracial and an interfaith gathering because we're here to talk about things that are not about one community in Asheville, not about one community in Buncombe County, but about matters that concern all of us who are interested in justice for all of our communities, who are interested in exploring and understanding our rights and responsibilities as members of the community, as well as employees of law enforcement agencies. So why are we here tonight? There may be some different opinions about the Florida verdict. That is possible. What we can agree on is that a young man is dead. So why are we here? When we've come together, organizers of this evening's meeting, we felt very strongly that we were not here to retry the Trayvon Martin case. What we agreed we wanted to do was explore for our community, explore for Asheville, explore for Buncombe County. How can we make sure that we know and that we understand North Carolina gun laws? That we know and we understand what neighborhood watch groups can legally do and what they cannot do. We want to make sure that we understand our rights and responsibilities as community members, and that we understand the rights and responsibilities of law enforcement personnel. We want to understand how to hold ourselves accountable, and we want to understand how to hold law enforcement accountable as we interact with them. We felt that tonight, most importantly, was about prevention. Most importantly, tonight, from our perspective in organizing this event, was about preventing similar interactions, similar tragedies in our community. We've invited Civil Rights Attorney Frank Goldsmith, Asheville Police Department Chief William Anderson, Buncombe County Sheriff Van Duncan to talk with us each for no longer than 10 minutes. You'll help me make sure that happens, particularly for the lawyer. Sir. That we would explore with these three gentlemen these critical issues, and after each of them has had the opportunity to make his opening comments, that with the help of Tyrone Greenlee, Deirdre Wiggins facilitating us, that we will then invite questions. Questions, again, about what we can do to keep our community safe. Now, the organizers have asked, and with the help of the church, with the help of some of our colleagues, that we are videotaping for the sake of future teaching our forum this evening. If for any reason anybody is not comfortable being videotaped, just say so. If you want to ask a question and you don't want to be videotaped, that's fine. Let us know. The organizers, again, have felt that there is an educational value for the future of what we're doing. Now, to make tonight work, we need your help, and we really do need your help. And we know that we are not going to resolve all of these challenges tonight. We recognize that. You recognize that. This is a beginning, though, and both the chief and the sheriff have made a commitment to us, and by extension to you. As we take these conversations out into the communities in coming months, the chief and the sheriff have committed to joining us in doing so. At the end of the program, my colleague Oralene Simmons will talk a little bit more about what our future plans are once we use tonight for an informational base. So I would ask you to help us keep the focus tonight. Again, we hope that you will join us in the future for these conversations. We hope you will bring your concerns, your ideas, your suggestions. Thank you so much for joining us. Frank?
Thank you very much, Carol, or should I say lawyer Hallstrom. I am really honored to be asked to be a part of the panel here and to share the podium with Chief Anderson and Sheriff Duncan. Carol told you that I was a civil rights lawyer. That is true. I have been practicing, or at least a large part of my practice has been civil rights law for longer than I like to have to confess, but let's just say about 40 years after getting out of my military service. And part of that practice has involved civil rights law as applied to the police and to law enforcement. And I will tell you that I have, during that career, I've probably sued most of the sheriff's departments in western North Carolina and many of the municipalities. And I'm confessing that to my co-panelists, but lest you think that I am biased against law enforcement because of that, I will also tell you that I have had the honor and privilege of representing law enforcement in many occasions. I've represented a great number of law enforcement officers whose own civil rights had been violated, and I have served as the local attorney for the Fraternal Order of the Police in my home county of McDowell County. So I am going to try to be objective with you and to try to share with you as objectively as I can my perspective on the legal issues that arise from the Trayvon Martin case. not, as Carol said, for the purpose of rehashing that verdict and determining whether that was the right verdict under Florida law, because I don't know Florida law. I don't know the facts of that case. I have found in my career that often what you read in the media about cases bears very little resemblance to what went on in the courtroom. And so rather, I want to use the fact pattern that emerges from that case, that is, an encounter between an unarmed 17-year-old young man on his way home and an armed, untrained, out-of-shape local vigilante who was a member of a community watch organization. That's what I know about the Trayvon Martin case. So I want to talk briefly with you, because I only have a few minutes to do this, about the legal issues that arise from that kind of encounter and encounters between both law enforcement and civilians and armed private citizens and civilians. In terms of the encounters that occur between law enforcement, and I won't spend very much time on this, there is really a sliding spectrum, if you will, of those kinds of encounters, and they are all governed by the Fourth Amendment to the United States Constitution. That says that persons may not be seized. It also says places cannot be searched, but we're talking about the seizure of a person cannot be seized except for probable cause, and that warrants for the arrest of a person or for the search of premises cannot occur except for probable cause. But that's pretty vague, so we need to see how that is fleshed out in real life. And so those encounters can begin with something as simple as a police officer asking somebody a question. Where are you going? What's your name? Show me your identification. Would you permit me to look inside your belongings? There is nothing wrong legally with any of those questions. Officers have the right to ask such questions. The next stage in this scale, if you will, would be what we call a stop and frisk. And that name comes from, it's sometimes called a Terry stop, because the case comes from Terry versus Ohio in 1968. And in that case, the Supreme Court held that it was permissible for a police officer to stop and briefly detain a citizen if that officer had reasonable suspicion that criminal activity was afoot. And that's really those are the words that the Supreme Court used. But the officer has to have reasonable suspicion. There has to be some basis in fact, in something that the officer can articulate as to why that particular individual was stopped on that occasion. It cannot be based on a hunch. And the citizen must be free to go if the citizen wants to. And so the standard really is, would the citizen understand that he or she was free to go? Or is the officer using such a display of authority that the citizen would not think that? And there have been a number of cases involving that. The most recent occurred this week. There was a class action lawsuit brought in New York against the City of New York Police Department by a class composed of African Americans and Hispanics who alleged that they were unfairly and disproportionately targeted by the police because of their race or ethnicity. And indeed, in that case, the Judge Steinland, found that there were 4.4 million Terry stops in New York City, 80% of which involved members of those groups, of either blacks or Hispanics. And that most of those were followed by a frisk. It wasn't simply a detention, but was followed by a frisk, a search of the person, the officer putting his or her hands on that person. And that only in 1.5 of those frisks was a weapon discovered. That's the only justification, by the way, for a frisk. So the judge has issued an order enjoining the city from these kinds of practices, and time does not permit me to go on into that case, but that is another stage in the spectrum. And then for a full-blown arrest, an officer must have probable cause with or without a warrant. And that is governed both by federal constitutional law and by North Carolina state law. State laws cannot restrict federal constitutional rights, but they can expand upon them. And in certain cases, they do that. But I want to leave the talk about interactions between law enforcement and citizens to my colleagues on the panel if they want to address that. You have heard the term a citizen's arrest. And indeed, it may be possible that that's what George Zimmerman thought he was trying to do when he encountered Trayvon Martin. In North Carolina, there really is no such thing as a citizen's arrest, except in one very limited circumstance. And that is where an officer seeking to make an arrest requests a citizen to assist in that arrest, and then that citizen is cloaked with the same basic right that the officer had and is immune from liability. What we do have is a citizen's right to detain, not to arrest, but to detain. But that detention can only occur if the citizen sees the commission of a crime, and it has to be certain kinds of crimes, a felony, a crime of violence, that occurs in the citizen's presence. And the detention has to be reasonable. The statute does not say what that means, but the case law indicates that it does not involve the use of physical force and certainly not deadly force by a civilian. The cases are things like where a supervisor at work stands in a doorway to block the exit of somebody until they can ascertain whether or not a crime was committed in that workplace. That kind of behavior. So it cannot be excessive force that is used by a citizen, and the citizen can detain only for so long as it takes for the citizen either to determine that no crime was committed or to turn that person over to a law enforcement officer. There is a duty immediately to turn that person over to a law enforcement officer. So those are some of the issues that arise in the facts of this case. The other issue that people have been concerned about and that you've heard a lot about are what we call the stand your ground laws, the right of self-defense. North Carolina and most states have always had a right of self-defense and have always said that you can stand your ground in your own home. If an intruder breaks into your home and you have a reasonable fear that the intruder is intent on doing you bodily harm or killing you, you have a right to stand your ground and use deadly force if necessary. In 2011, our legislature expanded that right, and they provided that this sort of stand your ground right applies also to vehicles, when you're in your vehicle, or when you're in your workplace. So your home, your vehicle, or your workplace are places where that expanded right of self-defense applies. And the statute, the North Carolina statute, says that it is presumed if somebody is intruding in your home or is in your home and refuses to leave and has gotten there by force, it is presumed that you are in fear of your bodily safety or of death. Now, even there are cases where that right of self-defense does not apply. You cannot have been the aggressor, for example, in bringing on the conflict. If you are the aggressor, you lose your right of self-defense. Florida law may be different about that. I am not sure. The only way in that situation, if you're the aggressor and you initiate the conflict, that you can have your right of self-defense restored is if you give up the fight and you clearly signal to your opponent that you are walking away from the fight, it's over as far as you're concerned, and then if the opponent continues aggressive activity towards you that puts you in reasonable fear of death or bodily harm, then you can use deadly force to repel that attack. The other limitation on that right is that you cannot use excessive force. So the force has to be balanced with the nature of the attack upon you. If I strike you with my fist, you can't pull out a gun and shoot me. That's excessive force. So those are some of the legal framework that governs these situations, such as perhaps arose in the Trayvon Martin case. It's a complicated law. There are a lot of other exceptions to it. You don't have that same right of self-defense, for example, if it's a law enforcement officer coming into your home or a bail bondsman. The statute protects both of those. So in North Carolina, my feeling is that the result of what I know of the facts of the Trayvon Martin case, which, as I said, may be flawed knowledge, based on what I know of those facts and what I know of the law of North Carolina, I believe the jury may have been differently instructed than it apparently was in Florida, and I like to think that the outcome could have been different if the jury had simply applied the law to the facts. Now, does that guarantee that there will never be racial bias in a jury verdict? Absolutely not. We all know that. But in terms of what the law requires, I think that's a synopsis and I sense that Carol is about to pull the hook on me and tell me that my time is up. She is nodding. That's a synopsis of what North Carolina law has to say about this situation. I'll be happy to entertain questions during the question and answer section that follows. Thank you very much.
Good evening. Good to be here with y'all. And this speaks really well for our community that we have a wonderful turnout like we have tonight. Thank you to Reverend Edwards for hosting at the church. One thing that we definitely agreed on as a panel as we started talking about putting this forum together is that we hope we never have an incident like Trayvon Martin occur in Buncombe County or Asheville. Could it happen? Sure. And we all felt very strongly that the outcome of what would take place after something like that depends on what happens before it takes place. In the dialogue, in the relationships, and in the understandings and trust that go on within the community. So we felt it was very important to come out and talk and answer questions and maybe give some background on the law. I am not going to debate Frank as much as Carol would like me to. I am not going to do that because I would lose. And I don't think you've ever sued while I've been there, so I'm good that we're going to stay out of that. So talking a little bit about self-defense. And when you talk about North Carolina, you talk about something that's called the Castle Doctrine that has been in existence for quite some time. And as Frank said, it has been extended to cover vehicles and to cover places of business, and we'll get into that in just a second. But North Carolina has always given a person the right of self-defense. And that's not just in the home, but there are some qualifiers for that self-defense to take place. One, you can't be the aggressor. Two, you have the obligation of reasonable retreat. So if somebody starts an action against you in public, and you have the ability to retreat, disengage, get away, you have that obligation of reasonable retreat. Now, where that doesn't apply, and believe it or not, very much the same standard for using deadly force by a law enforcement officer is very much the same thing as for a civilian, except there is no obligation of retreat because the law enforcement officer is called to be there and has a responsibility for the outcome of the situation that they were called there to take care of. In your own home, and you guys have probably heard this, if you have to shoot somebody, pull them in your house, right? And we do, y'all heard it, come on, I know that's not the first time you've heard that. And what that really comes from, it's not really so. What it comes from, something that we could talk about a little further, there's a couple things, reasonable person and totality of circumstances that come into play when you're looking at a self-defense situation. So if someone is breaking in your house and they are in your residence, it is already assumed that they are there to do harm. So a person in North Carolina could use deadly force at that point in time to stop that person who has broken into the house, whether they are armed or not armed. But what I'll also say is if you come out with a flashlight and a firearm, you confront that person, they turn and they run out the door, your ability to defend yourself stops at the point, and I mean ethically it stops at the point when you know the person's turning to flee and not gonna, and we can debate the totality of the circumstances and what happens there, and it's pretty specific to the individual cases. But if you follow the person out of your house, you've lost all that right of using deadly force for self-defense. Like I say, it's totality of the circumstances. I agree with everything that Frank said. One thing, if you're in public and you say somebody uses a fist and they're starting to physically assault you, you can't use a gun, but there are probably some totality of the circumstances where you could, such as the assaulter is a younger, larger person, and the victim might be an 80-year-old female. or a person who's disabled in a wheelchair. That's where that totality of the circumstances comes into play. Where North Carolina basically stepped up and extended those rights of the Castle Doctrine in 2011 was to a vehicle that you were traveling in and to a place of business. So if you are in your place of business, after hours, someone breaks in, or you're in your business and someone comes in and tries to rob that business, your rights theoretically of not having to retreat have been extended to you in your place of business. In a vehicle, if someone comes up to your vehicle, and that's where the totality of the circumstances and the reasonable person thing comes into play. If they come up to your vehicle and in a manner to open the door to get inside that vehicle to where a reasonable person would believe that they intend to cause them serious bodily harm or death, then the Castle Doctrine has been extended to be able to use self-defense. I am not aware of any cases, Frank, in North Carolina where that's actually occurred in a vehicle, but there are some pretty high-profile cases in North Carolina where it's happened in a business, and charges have not been sought out by the district attorney or the sheriff's office. And I think it was the sheriff's office, I believe, in Rockingham County, the one I'm thinking about, to where someone came into a business. So let me give you a caveat by saying, from someone who has worked situations where someone has used deadly force completely justifiably, it's the last thing you ever want to have to do. We talk, we get into a lot of community meetings that I attend quite a bit out in the county, and folks are upset. They've had their houses broken into, they've had some security taken away from them, and they're upset. And it's like, somebody comes in my house, I'm going to shoot them. Well, of course, we all have those visceral responses to having our security taken away. But what I will tell you, when that happens, even when you're 100% legally justified and even morally justified, if somebody's coming in and they're trying to harm you or your family, the bad thing has just begun to happen. And that's what I try to explain to folks, because everybody has a family, and hopefully everybody has a conscience, and you question what you've done. So this is a great opportunity for us to get out in the community and talk about these issues with folks, because in law enforcement, we always say you react to how you train, or you react to how you pre-think through situations. So this is a really good opportunity for folks to get the opportunity later to ask questions about that and pre-think through some of these things. How much time we got left, Carol? About 5 minutes? I'm good. Okay. I usually, see, Tim, I can be short and brief. Let's talk a little bit about Community Watch. Community Watch is something we are extremely supportive with. Community Watch probably prevents and helps us solve more crime than about anything else out there. A community member that's looking out for neighbors and taking information and doing those kind of things extremely enhances the ability of law enforcement to put resources where they need to be, to run down issues and things that we normally wouldn't know about from just a law enforcement perspective. Carl Ketterjohn is here, and he is the head of Crime Stoppers. That 250-5050 number has been huge for us in being able to get information in to solve crimes. So an aware community is a good thing. We would never instruct a Community Watch member to track, stay with, track down, interact with somebody that's breaking the law. They would have very much gotten an issuance of what they should do from dispatch, just like George Zimmerman got. Do not follow this person. Do not engage with this person. We tell Community Watch all the time, you are our eyes and ears, and that's it. As you start to engage, bad things can happen. How many of you have teenage kids? Me too. What I try to really point out to my son, particularly, and I think the chief's going to get into this in greater detail, especially when you're out operating a motor vehicle. You see a lot of this road rage stuff going on out on the highway. And because of North Carolina's Castle Doctrine applying to a car, I tell my son, let it go. If somebody comes by, disrespects you, cuts you off, whatever, let it go. Call law enforcement. If it's something that's serious, don't follow the individuals. Get a tag number, explain what's going on, call it in, and give the information. But then you have met your obligation there and let it go. Because now what happens is, with the expansion of the Castle Doctrine, is if somebody gets extremely upset, they get out of a vehicle, they go to the vehicle that they feel has wronged them in whatever way, and they start to open that door, it's going to be another case of witnesses, who do you believe, criminal backgrounds, what they might have posted on Facebook in the past, all those things, sir, all those things that come into play when they start to figure out what that criminal case is going to be. So we're going to have some opportunities here shortly for questions, comments, and I know that we want those to happen. But at this point in time, I'm going to turn it over to Chief William Anderson, and he's going to talk about responding to the police if you're pulled over.
Good evening. It's an honor to be here as well and see such a good crowd who has come out this evening. I'm going to talk a little bit about what happens if you're stopped by the police, but mainly my message is really geared to our young folks and some of the encounters that they might have. Let me start off by saying that the death of Trayvon Martin was a tragedy. For me, and in my opinion, it was a clear-cut case of a police wannabe overstepping his authority, and an innocent young man is dead. The purpose of me being here tonight is to educate, to talk a little bit about prevention, to give you, the audience, and especially our young folks, some pointers on how to avoid run-ins with the police, and if you do have an encounter, how it could have a positive outcome. I'm hoping that maybe what I cover here tonight might just save another innocent young person from dying or getting themselves into serious trouble with the law. We know Trayvon was not killed by the police, but all too many of our youth run afoul of the law. And I hope the following information and the information that I'm going to cover here this evening can help our young folks, and you take it back to your young folks if you have them, on how to deal with some of the issues when dealing with the police. What to do if you're stopped by the police, especially if you are a young person. We know that if you are a young person in America, there is a high probability you will have some contact with the police, especially if you're a person of color. Statistics have already showed this. We teach our children that it's not a matter of if you will be stopped by the police, but when you will be stopped by the police. Now, that's not to say the police are doing anything wrong or not doing their job or racially profiling anyone. They may be simply following the law and have probable cause or reasonable suspicion for the stop, like Mr. Goldsmith spoke of earlier. It's important that we teach our children that when that initial stop occurs, that we make good choices, that we make good decisions. We avoid any type of confrontation, but more importantly, we especially know our rights, and especially make sure that they understand what their rights are. There are 3 basic rules if you are stopped. Show respect, cooperate, and be honest. If you're driving and you stop by the police, the blue lights come on behind you, slow down and pull over to the side of the road. Stay in the driver's seat with both hands in sight. Turn down your music so that you can hear what the officer is saying. Listen and comply with the officer's request. Do not speak rudely. We have to remember that officers are human too. They're not perfect, and we all make mistakes. And they can have a bad day, just like everyone else. When asked to provide your driver's license, do so. Provide your insurance card and registration. Most officers will not tell you the reason they are stopping you until they have your license in their hand. Your car can only be searched if the officer has probable cause or you give consent. You have the right to refuse. Don't be afraid to politely tell the officer, you do not have my consent to search me or my vehicle. If you're issued a ticket, sign it. It's not an admission of guilt. It simply acknowledges that you have received the citation and you have the right to contest it in court. If you want to offer an explanation of why you were doing whatever, do it before the officer returns to his vehicle, because he or she cannot void the citation. If you're stopped by the police while walking through your neighborhood or on a public street, such as Trayvon was doing, answer all questions truthfully. Do not speak rudely, run, or walk away. The officer must have probable cause or reasonable suspicion to stop you. If the officer has reasonable suspicion you may be carrying a weapon, you may be patted down. Obey all requests unless it poses a threat to your safety. If you feel that it does, ask to speak with the officer's supervisor. What to do if you've been mistreated or suspect officer misconduct? Report it. Don't get angry and lash out. Ask to speak to the officer's supervisor. Go to the police department or sheriff's department and file a complaint. All complaints filed with APD are investigated, and you will be notified when the complaint is completed. In fact, you will receive a letter personally from me notifying you that the complaint has been completed. Misconduct will not be tolerated. I will not tolerate any misconduct. But first, it must be reported, and it must be reported accurately. Some of the other groups that can help in the community if you feel that you have had a bad experience with law enforcement is our local NAACP. And I know it's probably several members here in the audience that you can reach out to. The Asheville Buncombe County Community Relations Council is another local organization that can help anytime that you might have a negative encounter with the police. But I'll close by saying this. It is very, very important that we educate our children and we educate our youth, because that initial encounter that they have with law enforcement can be good or it can be bad. And we see all too often these encounters go the wrong way. So it's very, very important that we educate our young folks on how to deal with these type of situations should they be in an unfortunate position that they have to encounter law enforcement. A lot of the information that I passed out here tonight is part of a program called The Law in You, put on by NOBLE, which is a national organization of black law enforcement executives, and Allstate Insurance. My assistant in the back, she has probably about 50 copies of these. We really want to put them in the hands of our young folks. I think it's important if you have a teenage young person who's starting to drive, they need to read this. They need to understand what their rights are, how to handle themselves should they encounter a law enforcement officer. I think it will help them go a long way. Another pamphlet that we have is our Citizens Procedures for Employee Accommodations and Complaints. This will outline not only how to commend an officer, but also how to file a complaint with the police department. We appreciate this opportunity to come out and speak with you tonight. I'm sure we'll have a lot of questions, but I think it's very important that we recognize what happened in Florida. And as the sheriff said, do everything we can to avoid and hope that we don't have a similar incident in our community. Thank you for coming out.
I am Oralene Simmons, and I regret that we must conclude the conversation for this evening. But I'm going to try to answer some of your questions about what's next. This is not the end, but the beginning. We hope that this is the beginning of conversations in other neighborhoods. This kick-off community forum has been sponsored by the United Community for Justice. The names of our sponsors and our event organizers can be found in your program. Do we have any elected officials here with us tonight? If so, please stand, and also former elected officials. We'd like to know if you're here. Esther Manheimer was here. Who? Thank you. Anyone else? Lenny Sicknick is here. And how about our faith leaders? If you're here, you ministers, reverends, faith leaders, would you please stand if we have any here? Thank you, thank you. Thank you. Thank you. Much information has been given to us by the presenters. Some of our concerns and questions may not have been answered tonight. Let us keep this conversation going long after this forum has ended. We need your help, please. If you have a question that you would like to leave for one of the presenters, to be on our mailing list for notification of upcoming events, to be a sponsor, host an event in your neighborhood, be a part of the organizing, we would like to know. Please give us your ideas, your suggestions. We would like to have them. We have a number of clipboards. Isaac Coleman, are you here with clipboards? We have a number of clipboards that are going to be circulated. Please leave us your information. Leave us your card. Leave us a note. But we would like for you to use the clipboard for your questions. Host an event. How you can become involved. Ideas. We need your help, please. Our next event is scheduled for October in the Shiloh community. We thank you so much for coming out, but please do not leave without leaving us information.